as you've described, the initiative would return these cases to the trial court where they were first determined. What is the likelihood of a court overturning its own decision? I mean, especially in a high-profile case like a capital case, isn't there incentive to rubber stamp what they had done before? Why would they go out on a limb, short of some remarkable new discovery? What would change the course of events? And I guess the core of my question would be, if anything, don't these cases in further review benefit from a new set of eyes as opposed to going back to the original set of eyes?
So I would first split that question into two. I think the first piece is the Supreme Court is authorized to transfer the pending cases back to the trial courts. Those are the pending cases. New cases that come online, that's absolutely correct. It would be filed in the trial court right off the bat. So I think that that's a question in terms of whether or not the Supreme Court chooses to do so. That's a decision. And then I think on the second piece, we certainly can't speak to the decision that a judge would make. I think the proponents, and I think it's you can ask them when they're up here, I think that they would argue that the original judge who oversaw the murder trial has greater knowledge of what happened and is better equipped to make a decision that takes less time to make. So, but I do think that that's probably a better question for them.
Okay. The only other thing is I would add too is that the measure would allow it to be appealed to the courts of appeals in the Supreme Court, which wouldn't have heard it before.
And I think I had one more question for you. Anything we can learn from other states in terms of best or better practices? Do we know if a system like this is in place anywhere?
I think that we did not do a robust comparison with other states. I think part of our focus is when we are coming to our fiscal impact, we're really looking at our structure and kind of what it would mean for our system and the costs related to it now. In terms of other states, in looking at both different states have different attorney qualifications, they have different court processes, and it's really difficult to figure out how exactly it compares to California. And so I think that that's kind of a difficulty as part of the analysis.
And from your assessment of all of this, and I appreciate all the detail you've gone into it, you've put into it, is it fair to say that a bottom line goal here is to execute more people in California?
I think that the goal would be to speed up the state process. So in the appeals process, you have the state process, and then you have the federal process. We have no control over the federal process. I think that the goal is to speed up the state process and to shift it into the federal courts quicker. Then, as we kind of discussed previously, the federal courts may decide one way or another whether or not the limitations and the other requirements that are imposed by this initiative then allow it to continue on the same way it does now, or whether it makes different choices in terms of sending cases back to California for further exhaustion, et cetera. I think there are decisions that will be made there.
And I think in terms of the intent, also the proponents would be well positioned to answer that question.
Okay, thank you.
Hi. I have a question really about process and how to estimate costs, because I've always said where the rubber meets the road is implementation. And, one of the frustrating things about a proposition we just did, Prop 47, in it, I would say it had kind of a poison pill where the estimates for what the savings to the Safe Neighborhoods and Schools Fund would be based on one person's or one entity's determination, which was finance. And there was no checks and balances. It doesn't look like there might even be any input from the legislature. So if the finance department says it's only $29 million in savings, that's what it is. If we mean the legislature think it's $129, In some ways, they can tell you to go pound sand. And that's very frustrating because I don't think that's what the voters intended it to be. I think they intended to have some checks and balances. And so I'm really concerned about this because while we're talking about money in one proposition, this one, we're actually talking about people's lives. And putting it in the hands of the bureaucracy, which I'm very respectful of, and CDCR, and ensuring that the court system are all working together collaboratively to make sure that we don't make any mistakes. And I'm extremely concerned, and I don't know if you can answer this today. Are there any things in this measure that we look back a year from now and we may have to do another initiative, or we have to make some corrections within the legislature to fix something because because we have not fully figured out how to implement it? I mean, the discussions that we're having now, or even asking you about costs, you're like, we're waiting for CDCR to give us, or we're waiting for the courts to give us, or we're waiting for, you can't be redetermined until you actually put it in place. I think that's a little scary and a little frustrating. And so I don't know if you can, and I know we don't have a whole lot of time, I don't know if you can answer now, but if one thing I might ask is to at least do an analysis so that we know that the intent of this initiative is one thing, but are there enough information in here, hopefully there's no poison pills in here, to derail this and it turns into something else that we all regret later. And so that there's enough safeguards in here to ensure that whatever the voters vote on, whatever that they want, they intended to vote on, that they actually get that. And I think you know what I mean about unintended consequences from Prop 47 because you did the analysis. And so I'm very concerned that not only this initiative, but even the one we heard earlier this morning, that we scrub it to ensure that we don't have any problems later.
In terms of this initiative, I would say that the legislature will likely have some control on some things. So, for example, when I talked about attorneys and kind of how the state handles it, in its budget process, in deciding, whether to expand the Office of the State Public Defender or expanding HCRC, the Habeas Corpus Resource Center, or providing the Supreme Court or the Courts of Appeal for, with funding for court-appointed attorneys. That is a way that the legislature is able to participate in the decision. I will say that there are some factors here that are outside of our control that we really won't have knowledge about. So again, on the attorney side, what choices attorneys make. You can't really force attorneys to take on cases. And so how many attorneys are you going to have available? That is a question that's there. I think other questions involve how do the federal courts view this initiative? We don't have say in terms of what the federal courts decide. So I think that there's some aspects where the legislature has some level of control, involvement, and can have that. And then there are other areas that I think that the legislature has a lot less involvement.
Thank you.
Okay. Senator Leno, okay?
No, I forgot one question. Can you give us just a little bit of background and history on the Habeas Corpus Resource Center, when the state developed it, what was the reasoning behind it, given that this proposal would eliminate its board and limit its legal activities?
So my knowledge is that the Habeas Corpus Resource Center was created in 1997. And part of that was in response to the number of cases that existed. So in the same package that created the HCRC, it included kind of the parameters directing the Office of the State Public Defender to focus on direct appeals and capital cases. And so I think that that's kind of its origination. In terms of its structure, it currently has it's overseen by a 5-member board. The members of the board serve 4-year terms and are selected by, my understanding is selected by each of the various capital appellate projects in the state. And so that is the board that oversees it. This initiative would change that.
And do you have any memory of the problem it was addressing in its formation?
I think the idea was this issue of we just had quite a few cases that were awaiting for attorney appointment, and then you have the habeas type of cases, and then you have the direct cases, and I think the state just decided that the approach it wanted to take was to have this office focus on the habeas petitions, cultivate knowledge in terms of how you handle these cases, cultivate that expertise, and have the Office of the State Public Defender focus on its expertise in terms of the direct appeal type cases.
So the drafters of this then clearly want to reverse the decision made in 1997 and also attempt to eliminate the reason for the decision of 1997 by limiting the number of habeas corpus petitions altogether.
So in terms of the center, the HCRC would still exist under this measure. It's changing who has oversight.
Supreme Court would.
The Supreme Court and the board would be eliminated. Its activities would be limited in terms of, whether they were presenting habeas in the state versus at the federal level, et cetera. And so those are limitations on its activities. Separate from that, which I believe you're referencing, is the limitations on habeas petitions generally. Right. And I think that's a separate...
So wasn't it the number of habeas petitions originally that was some of the impetus behind forming the Resource Center?
I think it's the number of condemned inmates that were awaiting appointment of attorneys. So you're still in that similar situation now where you have, I think it's 360 individuals who are awaiting habeas, appointment of attorney for a habeas petition. You'll still have that. It's now going to the trial court level. The trial court would be authorized to appoint that attorney. The big question is whether or not, in having it start at the trial court, whether or not you would need to appoint new attorney at the Court of Appeal level. And so that is an operational question that would have to be answered.
Okay, thanks for the history. Mm-hmm. Thank you.
Thank you. I think, thank you very much, LAO. We're ready to move on to the first panel discussion, which will be the proponents. Kermit Alexander, the official proponent of the initiative, Anne Marie Schubert, the Sacramento County District Attorney, Mike Ramos, the San Bernardino County District Attorney, and Kurt Schneidiger, again from this morning, the Criminal Justice Legal Foundation. Welcome to the committee.
That was my microphone. I'll see you.
Okay. We have 45 minutes set aside for this presentation, and hopefully you'll leave some time for questions from the committee, but in any way you wish to proceed.
Thank you, ma'am. My name is Kermit Alexander, and I am the proponent of the Death Penalty Saving and Reform Initiative. In 2012, when Californians defeated Prop 34, we did so with a promise that we would fix our death penalty by reducing costs, providing remedies for lengthy delays, ensuring immediate representation for the convicted, and most importantly, carrying out the process of justice for those who have violated California's laws to such an extent that they merit death. In August 31st, 1984, my mother, Ebora, just 59 years old, along with my beautiful sister, Deetra, age 24, and my two young nephews, just 8 and 14, were gunned down in the early hours at my mother's home in South Central Los Angeles by two armed gunmen, one lookout guy, and two female getaway drivers. My mother was just starting her day, still in her nightcoat and slippers, sipping her morning cup of coffee. She had just come in the front door after hosing off the front porch, forgetting to lock the screen behind her. My sister was still in bed, and my two young nephews were sleeping on the floor just a few feet away. Just minutes before the murders, the hit team argued about where to find $2, just enough to buy a gallon of gas for the van that would drive them to carry out the hit that would result in the assassination of the Alexander family and hopefully to provide for their getaway. Night after night, I walked the streets of LA looking for these killers, wanting to extract revenge. But because of my status in the community, in my professional career with the Los Angeles Rams, the law enforcement community, including Police Chief Daryl Gates and Mayor Tom Bradley, promised that if I would surrender my vigilante efforts, they would seek justice for our family. And the law guaranteed it. In 1984, fueled by an increase in crime and a demand for greater public safety, California was resuming the use of the death penalty, and that is the penalty the jurors in our case felt the main trigger man deserved when he accepted money for an assassination for hire. The unfortunate part of this story is that this hitman had gone to the wrong address and brutally murdered 4 innocent members of our society. His comments immediately following the shooting, "I just blew the bitch's head off." That was exactly what he did, leaving a trail of brain matter, shell casing, and blood embedded into the walls and window sill of her kitchen. Justice is not easy, and it is certainly not gentle. But justice denied is not justice. We, the people of California, have consecutively and systematically voted to reinstate and preserve the use of capital punishment, despite the efforts of those who refuse to carry out an execution. Recently, in a media interview, someone asked my sister Mary what it felt like for the Alexander family to consider when or if justice would ever be served. Her answer: "It feels like being in an airplane, circling around forever without a destination and no place to land." Justice is not easy, and it is certainly not gentle, but justice denied is not justice. On the day of the murders, if a bystander or the police had shot these killers as they were running out of my mother's house, we would have hailed them as heroes, given them awards. But 30-plus years later, somehow these killers have regained value. Yet there has been no apology from the killer and no justice from our government, who vowed to obey the laws and represent the democracy that we live in. And my mother, sister, and 2 little nephews still remain in their graves, and my family is still having to fight for justice. I thank you for allowing me to be here today to give you the wishes of my family, the understandings that we have historically that we believe in justice, and we're fighting to live our lives as best we can, hoping that it will prevail.
Thank you very much.
Thank you. Good afternoon, members of the panel. Thank you for this opportunity to come and speak to you. I'm Anne Marie Schubert. I am the elected district attorney of Sacramento County. I have been in office for a little bit over a year. Prior to becoming the elected DA, I was a deputy DA for upwards of 25 years. So today I bring to you not just as the co-chair of this initiative, but my 25 years of what I call living in the trenches of crime on the streets of Sacramento County. My background before becoming the DA was the majority of time spending in the area of forensic DNA evidence. I believe very strongly it is the greatest tool ever given to law enforcement to find the truth, no matter what that truth is. In 2002, I was fortunate enough to start our office's cold case homicide unit. And at that time, I went to all the local police departments and asked them, if there's any unsolved cases, which ones would you put at the top of the list? And unanimously, everybody from the Sacramento Police Department named one person, and that was a woman by the name of Eva Chu. In April of 1979, a couple days after Easter, Eva Chu happened to work for the state. She worked a few blocks from this building. She was 7 months pregnant. And she left at 3 o'clock on one day in April of 1979 to go to her 7-month checkup. She also happened to have a daughter that was 2 years old. She was abducted from the parking garage that was about 3 blocks from this building. She was taken to an area off of Interstate 80. She was raped. She was sodomized. She was strangled to death, and she and her unborn child, Kelly, were found a few days later. That case was solved for no other reason than by DNA. That case went to trial by another lawyer in our office, and the individual who had raped and killed her and her unborn child was given a verdict by a jury, which was that, given his background, which was he was in prison for another crime, horrific crime, the jury recommended the death penalty. And not long after that came Prop 34. And so I felt that based upon my experience with these types of cases, that I would become involved because we needed to fix the death penalty, not abolish it. So when Prop 34 came around in 2012, that's when I met Kermit Alexander, and I understood what happened to his family. But I also met the mother of an 8-year-old boy by the name of Michael Lyons. That case too affected me, perhaps because I too have an 8-year-old boy. But in 1996, Michael Lyons was walking home from his school in Yuba City when he was abducted by a serial sex offender by the name of Robert Rhodes. He was taken to a riverbed, and he was brutally sodomized in Mr. Rhodes' pickup truck. And when he was apprehended, they found his footprints on the window, inside of the window, Michael's footprints of that pickup truck. He was brutally sodomized, raped for hours. His throat was slit, and he was left in the bottom of that riverbed. That case went to trial here in Sacramento as a change of venue, and a jury recommended the death penalty. But a few years later, after that death sentence came in, Mr. Rhodes was identified yet again with the murder now of an 18-year-old from Alameda County by the name of Julie Connell, who in 1984 had gone to a park in Hayward because she was a straight-A student who liked to study. She too was abducted, tortured, raped, and murdered by Robert Rhodes. Number of other crimes that Mr. Rhodes committed. That case also went to jury in Alameda County. And after hearing that evidence, within 1 hour, that jury came back and recommended the same sentence yet again for Mr. Rhodes. And so when we sit here and debate the very important policy of whether or not the death penalty is an appropriate option that a jury should consider, we cannot forget about the facts of crimes like Kermit Alexander's or Michael Lyons, because that is why we sit here today as proponents of this initiative. And I have said this once, and I will say it again and again. What is the point of seeking the death penalty in the state of California if it doesn't work? It is our obligation, and Prop 34 came out, and when we fought to keep it, we made a promise to the citizens of this state, which was, we will fix it. And we're here today to deliver on that promise, to put forth all the recommendations that have been made for the last 15 years by individuals like Joel Anderson or Senator Sharon Renner. 15 years of legislation to try to fix this system. And so now we're taking that to the voters of California. The facts and circumstances of these crimes are what needs to be at the forefront. The fact that there are over 1,000 victims of people from death row, 200 plus children, 40-something police officers, hundreds of women that have been sexually assaulted and tortured before their death. As the elected district attorney of Sacramento County, since January of 2015, when I came into office, our office has filed 157 murder cases. Just last week, I had my first conversation on a case on whether or not we should seek the death penalty. The first and only conversation. It involved the sexual assault, murder of a 6-year-old child in this community whose body was set on fire and dumped in another county. One case out of 157. It's a rare event. As you've heard many, many times today, it should always be a rare event. This initiative is designed to deliver on the promise, which is to fix it. So today I'm going to ask my colleagues, Mike Ramos, District Attorney of San Bernardino, and Kent Scheidegger, to talk to you about what this reform initiative does. 3 things: reform the housing and victim restitution, as you heard from the LAO, reform the oversight process and execution protocols, reform the appeals process. Thank you for this opportunity to speak to you today.
Thank you. My name is Michael Ramos. I've had the honor of being the elected district attorney for San Bernardino County 4 terms. This is my 14th year, and prior to that, I was a trial lawyer for 14 years. I also have the honor of knowing Kermit Alexander as my friend, and his wife Tammy, and my partner, my co-chair of the Death Penalty Reform Initiative, Anne-Marie Schubert, because of the passion that you've heard today. I will share one case only because it relates to why we need to reform and fix the death penalty. In my last death penalty trial as a trial lawyer, it was the murder of a young girl, Marilyn Mishak, who chronologically was 32 years of age but had the mental capacity of a 12-year-old. Her parents put her in a condominium a mile and a half from my home in Redlands, California, in a nice neighborhood. She was an ROP to try and get her some more independence so she could be self-sufficient. An individual one night at midnight busted into her home, an individual who had served prison time up in Oakland, California for committing a residential robbery and brutally beating an elder lady who survived and identified him in court that put him in prison. After he was paroled, he went and canvassed the neighborhood, and he got into Marilyn Mishak's condominium. About midnight, brutally strangled her, stabbed her to death with her own kitchen knife, and pulled down her pants and underwear, and we believe was going to attempt to rape her, but she was so scared and distraught that she defecated. Her father found her the next morning because she didn't make it to ROP. I tell you that story because her father, through the whole process when we were seeking the death penalty, he wanted to kill himself. In fact, to the point where the court put up metal detectors for the father, not anyone else, but for the father. And I told Mr. Mishak, please let the system work. You have to trust the state of California. We will get justice for your daughter, Marilyn, with the death penalty. He never came to court, and he finally came to court on the last day of the penalty phase. He hugged me, he cried. I still see him in the community. He cries, and he thanks us. And I can't imagine going back to him and saying, the system we told you about did not get the justice that you wanted for your daughter's murder. So that's why it's such a passion for myself and my colleagues that you heard this morning as well in the afternoon. As my good friend Jackie Lacey from LA says, this initiative isn't about jumping up and down and cheering, yes, let's put these people to death. No. It's about a reform. It's about doing justice. It's about an equal protection, constitutional. I heard those questions for both sides. This individual I just talked about didn't get an attorney for almost 6 years. I mean, that's not fair to those individuals as well on death row. And to start their process, to start their proceedings. And I guarantee you, every DA that has tried a capital case ethically through the whole trial process is very careful protecting the accused rights. In my case itself, for a time, he went pro per. I helped him put on the evidence because I wanted a fair trial. I wanted the truth to be known, and that's what this reform is going to do. One of the things the public really opens their eyes about, and they can't believe it when we talk about the reform and allowing CDCR to move inmates off San Quentin into a general population where it's more modern, the security, it's not as expensive. And so some people may say, well, these people are the worst of the worst. They are. We use our discretion in seeking a small percentage of those that we put on death row. But there are also inmates, like my colleague, District Attorney Mike Hester in Riverside, prosecuted an individual for arson that killed firefighters. And he said, you know, if I get the death penalty, that's all right. I want to become friends with Scott Peterson, the person that murdered his wife and the baby, so we can play basketball together. Guess what? That's what they do. He is befriended, and they get out, and they get to go play basketball, and they're on death row. Those two should be in a general population working to pay the restitution back to the families of the victims, both Lacey Peterson and the firefighters' families and their children. The other issue, we've talked about the oversight. I'll let my colleague talk a little bit more in detail, but it's about 2.5 years ago I met with Governor Brown and I was the president of the California DA's Association. I asked him about a single drug protocol. Can we go there? And he said yes, and he talked to CDCR about it. But I was naive. I had no idea about this Administrative Procedural Act and what a wall it was going to be to get through. In that situation, you have a public hearing. You have to respond to everybody that makes a comment or a hearing, and you have to, if not orally in the hearing, you have to do it in writing. I don't believe that's in any type of proceeding. I can imagine what would happen in the Capitol if that happened here, trying to legislate. So we're just asking to remove that. People can talk about their opposition to the death penalty, and we'll never be able to change that, and I respect their position. We're just asking for a procedural change to make this fair and more efficient as we go down through the process for victims' rights. And I guess that's what I want to end it with is we have respectfully tried to fix this and reform this in this building, and for many reasons it wasn't done. So now we have an opportunity with 2 initiatives to let the voters decide, and that's really what we want to do at the end of the day.